Lord, with regard to item 17 from your lordship's today's
17.
71-7. Lord,
Somebody just mentioned.
Huh?
Somebody had just mentioned 71.
not 17, 17, 1-7.
Oh, yes.
17 under the hearing adjournment motion. Lord, I am appearing for the petitioner. Lord, I am having fever and I caught cold, sore and running nose. Lord, I am lordship is kindly accommodating for a week's time. Lord, in this situation, for the possible for me, I am not in a position. Only for this purpose I have come. I shall go back home. 17.
Is submitted by Learned Counsel for the. Please give the case number on a piece of paper. Give the case number on a piece of paper. The Learned Counsel for the petitioner submits that he is unwell and will not be able to render proper assistance today. Stop. He seeks a week's accommodation. Stop list accordingly after one.
Still in force, Your Lordship.
Oh, that railway matter.
Your Lordship.
Very well.
Nothing written instructions have been given, but we had we
Is
said it is
submitted by the.
Item number 2. For the petitioner, my lord.
Yes.
This is the matter, my lord, in relation to that Geological Survey of India, that physically disabled person.
What is the correction?
My lord,
Oh. The matter has been placed at the instance of the office.
Authority has rightly decided that not to be.
Anything which was not before the tribunal, we will not consider. Whatever was before the tribunal, we will only
That
consider.
tribunal, that's why this is the, how much, my lord, marks have been allotted.
If the material was not before the tribunal, we shall not consider it. Yes.
Matter may be, appear.
Instead of listening, you are saying that is why you don't.
Next one.
Has been filed in those cases by those petitioners saying that we will not claim anything other than this.
No, my lord, no affidavit has been filed, my lord.
Huh?
In the petition, my lord, we have made a declaration that in our application to no objection, we made this application that in the event, but no affidavit has been filed.
Direction ছিল ওইটাতে আগে।
That application was there was a direction to file affidavit. We have filed the affidavit.
When we don't find it in the record.
But in this application, my lord, there is no affidavit, my lord.
না না
Claiming parity with those petitioners and you are claiming parity with those petitioners and
My lord, only thing, my lord, although we have not filed an affidavit, and because in that matter, my lord, the court directed us to file an affidavit. Well, I will file an affidavit, your lordship, so directs, my lord, we'll file.
why should we direct? You decide whether you want to file or you don't want to file.
My lord, in my page 72 of the application, my lord, I made it clear before the authorities concerned, my lord, I just reading it out. I also undertake that in the event of my selection in the applied post of associate professor in the Department of Anesthesiology at AIMS, Koladi, I will tender resignation. I will never claim any benefit of my past service under Government of West Bengal except GPF and GIS as per rules. Well, that is stated before the authorities, my lord, in my application.
They are in all the, but you didn't place this.
My lord.
It is in all the writ petitions.
All the petitions are there, my lord.
Which annexure?
No. This is annexure, my lord. Page 72 of the first application, my lord, page 72. My lord, it's annex my lord, the annexes of the tribunal application.
ট্রাইব্যুনাল অ্যাপ্লিকেশনও আছে মানে প্যারাগ্রাফে
And the application
Wait,
before the
wait.
tribunal, my lord,
কোড আছে কোড আছে ইন দ্য ইভেন্ট এই যে ইন দ্য ইভেন্ট পেজ
No.
22
and my lord, you will find also, my lord, in the tribunal application that is there, my lord, at paragraph, my lord, 4x, my lord, Roman 10, I've also made the averment that I will tender resignation. Okay, thank you for taking class.
পেজটা ওইতে
Section number.
My lord, page 72 of the first application, my lord.
Second case,
Second one is, my
application
lord,
means can.
no, my lord, in the original WPS, writ petition.
Yes. Second
Page
case,
72, my lord, this amendment is made.
second case.
Second, my lord, just. No, no, ওইটা না, যেখানে তুমি দিয়েছো, application. The second one is that page. 72. This is also, my lord, the next one is also at page 72.
Third.
Third one is, my lord, page 71.
Yes.
And fourth one, my lord, my lord, page 25, I made the amendment.
25 of WP.
WPST number 218. Well, page 25, paragraph 10.
So that you have made the above.
Yes, my lord.
In all the cases, this is there. You
Yes,
didn't place this that day.
my lord, I'm extremely sorry, my lord.
For judgment, for judgment. No, we must, yes. Matter is adjourned, not.
Item number 7.
Well, it is a part-hard matter. Initially, it was hard before the Honorable Justice Taubrata Chakraborty and Partha Shanti.
It is submitted by the learned counsel for the petitioner that the there is no representation. Same order. Just instead of petitioners.
I have put the respondent.
Just record the respondents appear.
My lord, I'm appearing on
Respondent.
respond.
Same order. None appears on behalf.
I was on legs in another court, Your Lordship, in court 3. So I am for in item number 9, Your Lordship.
Has been passed in presence of the respondent. Respondent has appeared in it. No.
Lordship, I was arguing a matter. I'm really sorry, Your Lordship. I ran and came. Item 9, Your Lordship.
You are for? You are for?
I'm for the Union of India, Your Lordship.
Respondent.
So, Lordship.
Give
Union
your
of-
appearance. Give your appearance. It is dismissed for default. What is this? Second day non-appearance. 11. You are for respondent. Then somebody should be here. How it can be done like this? In 11, perhaps the respondent has appeared.
Yes, Your Lordship.
Then what can be done? Oh, you are here.
Yes.
So we'll take that up. In 9, you are for respondent, madam.
Yes, Your Lordship.
All right, give your appearance. Okay. Call 11 again. Then we take up.
Item number 11.
Lordship, I'm for the Union of India. Union of India is the petitioner, Your Lordship. I'm so
We
sorry.
are asking you
I'm so
repeatedly,
sorry,
you
Your
don't know your own status.
I'm so sorry, Your Lordship.
Peculiar.
I'm so sorry.
In 9, respondent has appeared.
I'm for the Union of India. Union of India is the petitioner.
Sorry, we can't do anything. Respondent's presence is not, in his absence, we are not going to pass any order.
I'm for the Union of India, Lordship, the petitioner.
That doesn't help. Your respondent is not here. The order was passed in their presence. It can't be recalled in their absence. Yes, you please
Lordship,
proceed.
kindly it doesn't do this, Your Lordship.
We are sorry. Yes, item 11.
Lordship, I'm humbly praying, Your Lordship. Lordship, I'm humbly praying, Your Lordship.
If you approach any
I
proceeding,
just had
if-
surgery, Your Lordship. I'm not able to run that much.
if you approach any proceeding with an open mind, you will get the solution. If you don't, we can't help you. We are telling you in their absence, we will not pass any order. Why don't you understand what we are trying to say? Yes.
Can you give the appearance?
You are for?
I'm for the petition.
Yes, sir.
My lord, in 2006,
original application was filed by the two applicants paying for certain benefits of monetary relief due to fixation of pay.
Areas of salary and all that.
Yes. What just fixation of pay. Then what are not
So only fixation or the areas arising as a result of
fixation of pay.
only,
Yes.
no areas.
Yeah. Then what are the 1st of March 2011, but the applicant number died. Then what are they filed an application for substitution setting aside amendment. When that application was withdrawn. Withdrawn. Now, one of the application was verified by the applicant number 1 under the rules framed by the central government. Then, now the question is to be decided if then, when the matter was taken up for final hearing, the learned tribunal directed that since similar benefit given to the petitioner number 2 or legal heirs of the applicant number 1 and also the petitioner number 2. Want to kindly see the rules? Want to kindly see the order passed by Lordship, passed by the tribunal. Page 85, order dated 30th August 2022.
Thirtieth August.
30th August 2022, page 85. Have Lordship got it?
You have not given a certified copy of that order.
Yes. Certified copy of the order passed by impin order.
No, we don't find that order of 30th August.
Impin order dated 8th December 2022.
8 December.
Prior to that, page 85, that application for substitution was withdrawn.
No, you said 30th August, therefore we are wondering, it is 8 December. It's not 30th August.
8 December is the impure order.
Yes.
No, prior to that, if you Lordship can say page 85.
Oh, page 85.
Yes. Have Lordship got it? In a course of the hearing, the learned counsel for the applicants have submitted that he wants to withdraw both the MAs liberty to take appropriate step. In view of the above, both the MAs are dismissed as withdrawn. Therefore, the applicant is liberty to take appropriate steps is advised. Then, the application for substitution and application for
This withdrawal is, there are how many petitioners?
there are two applicants.
Two applicants.
Two applicants. And one application for substitution, one application for setting aside amendment. That was withdrawn.
So applicant number 1 withdrew.
No, both the applications
Oh, both the MAs are dismissed.
dismissed.
One is for substitution and another for
Setting aside amendment.
Oh, MAs have been filed.
yes. With the
On
application.
behalf of which applicant? First,
Applicant number 1.
is what we are saying. Setting aside abatement. The CPC applies to this.
But under the rules framed by the central government under section 35 of the Administrative Tribunal Act, that want to kindly see the Administrative Tribunal Act.
Yes.
Civil Procedure Code does not apply to the proceedings, but principles will be that.
Paragraph?
Kindly see section 22(3),
Section, yes, section 22.
2 subsection 3. Have you lordship got it? And last is any other matter which may be prescribed by the central government. No. ওখানে নেই কালকে বাদ করে দিলাম। এই একটা।
So after this, they withdraw.
Oh.
Applicant number withdrew from the proceedings. What happened?
Or the relief has been granted to the legal heirs of the
First applicant also.
first applicants.
So, Your Lordship, can you look into the order?
Yes, kindly see. Now, kindly see the notification issued by the central government on 21st December 1994 at page 19. How verification has to be made? Verification was made by the applicant number 1.
Where is the provision regarding verification?
Now, kindly see section
Rule 4.
yes. Procedure for filing an application. And how verification has been made, that is at page 19.
Rule 19.
Page 19. Top verifications. Name of the applicant, son of working as a whether I put to my knowledge and belief and that I submit any material. Well, this who has verified these applications? Can you see the applications? Verification column. Page 44. Basuki Devna, page 44. Son of let such and such, applicant agent of such and such. But if this verification goes after the date of the person concerned, whether that application can subside or the application order 22 rule 2 CPC.
No,
Abbott.
but before that, let us see
Hmm.
whether the order has been passed in respect of applicant number 1.
Yes.
also.
Here, lads, you can see at page order dated 8th December 22. I'm reading from paragraph 2. The applicant as a gauge reader is praying for a second the input order of the respondent appearing at page 36. Earlier, tribunal in the matter directed authority to grant revised pay scale to all the petitioner gauge readers. Pursuant to this order, the applicant has moved the application as being similarly circumstances and praying for similar benefit as giving way number such and such, with the direction to the respondent to issue necessary order granting revised pay scale to all the petitioner compliance of the High Court's order. In compliance of the respondent issued an order number such and such, dated 10th July 23 granting scale of pay. The applicant neither states that neither the High Courts or nor in the tribunal's order the revised pay so granted was to be treated as a personal pay. From the various administrative orders, it has been proved that scale of the pay of such and such has been accepted as a basic pay scale for qualifying gauge readers. However, the depository by memo dated 29 July 2005, issued an order to the effect that the revised pay scale granted to the Honorable High Court by the Honorable High Court as a personal pay of the individual petitioner and not basic grade pay scale of the wage leader, and therefore they would not be entitled to any benefit at the career advancement schemes of 1990 or 2001. Thus, any effects of the benefits received under CS scheme are not refunded. Mr. Banerjee, appearing on behalf of the applicant, submits that the implementing order to be quashed and set aside and direction to be given to allow the applicant to continue with the pay scale and CS benefits. The Banerjee also relies on the order of the tribunal number such and such. In this order, the tribunal, after consideration of the entire matter, set aside the matching order of 29 July 2000 with further direction to grant benefits fitting the scale awarded to the Honorable High Court as a basic PLO in terms of due dated 21st June 90. The relevant portion of the judgment is protected. According to the light of the above discussion, the present applicant is allowed and the order dated 3rd January 95 and the relevant matching orders are quashed. The respondent authorities are directed to grant the benefit of cash benefits treating the same scale awarded to the applicant in terms of the order of the High Court as a basic pay in terms of geo dated 21st June 1990, followed by the fixation in respect of subsequent benefits in accordance with the rules within a period of 3 months from the date of publication of the order. It is not permissible to deduct any amount paid to the applicants on account of earlier award of cash or modified career cash. If such amount has already been deducted, the same shall not have to be refunded within 3 months from the date of publication of the order. Therefore, Mr. Banerjee is to submit that the applicant in this present application is similarly circumstances and tribunal may be pleased to pass an order similar to the way numbers are. Mr. Ghosh, appearing on behalf of the submits that the matter is already settled matter by an order of the tribunal. Present application is also similarly situated applicant numbers are. Therefore, order directing the respondent to pass a leading order will be appropriate. Mr. Banerjee further says the benefits of this case may also to the members of the deceased applicant of E.N. Bhatak. Malamada, who was not before the court, who was not substituted, he should be given effect to. After hearing both the advocates considering the facts of substance, I declare the applicant's matter is also similar situated by the way number. I direct the respondent number 4 to consider and dispose of the matter in the light of the earlier order within 3 months from the order. While considering that the respondent will also see if any amount has been deducted from the same amount shall be refunded within a period of 3 months for the who has expired during the pendency of legally or submits any representation and shall be taken into consideration. But a relief has been granted to the legal heirs of the, that means without an application for substitution. As soon as one of the parties died, the proceedings abated on our order 22 rule 2.
Yes, we have understood. You are saying that he did not press his substitution. He has, therefore, he is not on the record. The matter has abated insofar as his claim is concerned. Therefore, the tribunal could not have directed that his case should also be considered.
Yes, I'm grateful to.
Yes.
My Lord, first thing, Your Lordship, that my learned friend has added these
You are appearing for the first applicant.
both the applicants. I was appearing before the learned tribunal.
Why did you withdraw the MA?
That, how my learned friend has added the person as a party in this proceeding, when those persons were not added before the learned tribunal. They were not parties before the tribunal because they withdrew the application. Irrespective of that, they had named those persons.
They are a necessary party now since the order has been passed in their favor. Now they are a necessary party. That is no objection. Order has been passed in their favors, your favor, in fact. You are the representatives.
Yes.
Who do you
Filed an
represent?
application.
Who do you represent?
Represent here, both.
No, you represent respondent number one's LRs.
The wife and the children.
Wife and how many children? 3.
2 children.
2 children,
You have
wife and 2 children.
pleaded them.
Yes, page 3.
And Your Lordship, it would be evident that in the before the learned tribunal, we had specifically stated that why we could not make the application for substitution on time. We had specifically stated that Section 5 application.
How can we look into something which you have withdrawn?
We had stated, that's what I'm saying.
How can anyone look into it when you have withdrawn the application? Cannot look into it. Why did you file an application for substitution?
8 years delay was there.
8 years.
8 years delay was there. That's why I could not satisfy the delay.
What is the date of death?
Date of death is 1st August 2023.
1st August
1st March 2011.
And when did they file the MA?
Original application filed in 2006.
No, MA. When did they?
MA filed in on 2nd April 2022.
2nd April
2022.
22.
Yes, exactly.
Application was filed on 17th September 2019, as would be evident from page 83 of the application.
Oh, sorry. Sure. Yeah, 17th September 2020.
Yes, you said 8 years.
Huh?
You said 8 years.
About 8 years.
So that is correct. 22 will not be correct.
2011 and 2019.
That appears to be correct.
8 years, about 8 years.
Want to file any opposition?
But Your Lordship to decide it. I cannot make anything new out of it.
Yes.
I leave up to Your Lordship. But the only thing, Your Lordship, that no
What
order
is your submission on these rules?
rules.
Yes, he is referring to rules.
Yes,
You are representing the respondent. You don't want to make any submission. He is referring to the provision contained in the rule. What is your submission?
But on that, Your Lordship, I'll be using a short affidavit.
Yes,
Using a short affidavit.
on this point of law, you will file an affidavit. He is saying this is the provision in the rule for what an affidavit needs to be filed. You assist us with reference to the rule.
My Lord, what I submit before Your Lordship is this: if a person dies, 2 petitioners are there, 2 applicants are there. So one of them has affirmed that affidavit. So on the date after, Your Lordship, as it be evident, my Lord, from the verification, that applicant number 2 has authorized the applicant number 1 to verify and affirm the said affidavit. So after his death, there is no questions of re-verification by the surviving.
That is not what he is saying. You have not pressed your application for substitution. You are not before the tribunal.
That is in respect of only one applicant.
Yes, he is only opposing in respect of one. Is not you are opposing in respect of only one.
What my learned friend has earlier submitted, that the entire application got abated.
We are hearing him today. We have heard what he has said today.
Yes,
So he has not said anything about the other person.
On a verification, if it goes, then entire thing goes.
Both the petitioners.
Both the petitioner. An application for amendment has to be filed, just nothing more. 1-page application.
There is no rule to that effect, that after the death of one of the applicant, the other applicant requires to file an amendment application.
Order 22 rule 2.
Not even in the before the civil court is following the CPC. And furthermore, your lordship, with respect to applicant number 2, the opposite party number, party number 2 here, your lordship would be kind enough to look into the order. The second last page of the order. The order was passed on consent. The state has given the consent. Mr. Ghosh, appearing on behalf of the state, submits that the matter is already a settled matter by an order of the tribunal in OA 11786 of 2007. The present applicant is also similarly situated as applicants of OA 11786 of 2007. Therefore, an order directing the respondent to pass a reasoned order in the light of order in OA 11786 of 2007 will be appropriated. This is the submission of the state. My lord, the order that's been passed for my learned friend has submitted with your lordship with regard to the years of the applicant number 1. Lordship, only the last portion that's the only portion it speaks of is that there's a direction upon the respondent. If his legal years submit any written representation, the same shall be taken into consideration similar to respondent number 2. If that is the grievance of the state respondent, so lordship, let the last line be struck out. The same shall be taken into consideration similar to respondent number 2. This is the last line may be struck out by your lordship. Because other portions of the order, entirety of the same, nothing in that such. There is any such direction upon the respondents that is speaking in this order. Only the last 2 lines. Last 1 line, your lordship. Representation being made by the heirs of opposite party number 1, then it's all up to the respondents, your lordship, whether they are to consider or not. There shouldn't be any direction of this honorable court.
Section 21.
21, 20. Give me take that.
It's section 21. Of the original application.
Is there any specific provision for a substitution?
No, there is no such procedure, except these rules.
No, in this rule, there is nothing about substitution.
But the substitutions only provides in order 22 rule 2.
That is not applicable by express intention of this legislature contained in section 22. That will not apply.
And subsection 3, kindly see for a moment.
Shall not be bound by the procedure.
Yeah.
That is a specific mandate of section 20.
Subsection, subsection 1, outstate the applicability of CPC, but subsection 3 said that tribunal shall have the purpose of discharging the funds or under the Act, same powers as vested in the civil court under the Code of Civil Code 1998, while trying a suit in respect of the following matters.
No, that is for summoning and discovery and all that. That is for a limited purpose.
Limited purpose.
That is not in subsection 2, that is in subsection 3.
Then how the substitution date took place, then within 90 days, amendment takes place. So takes an amendment another 60 days.
No, you are presupposing the application of CPC. That is the whole issue.
Yeah.
You are presupposing the application of CPC and you are not
Assuming for a moment, that CPC does not apply.
no, not assuming.
No, no, just
That
keep
is
it.
the specific explicit mandate of the act.
Yes.
There is no question of assumption and presumption.
No, no, I'm for a
It
moment.
is very much explicit from the statement of the legislature incorporated in section 22 that shall not be bound by.
Yes.
That's no, has no binding effect.
Yes.
Yes.
Now, assume for a moment. Then, my lord, what would the effect if somebody dies?
So we are asking you, is there any provision in the act or the rules? If there is no provision, then first we want to see whether there is any provision, whether a legal heir can make an application, how the tribunal will proceed if the substitution was made in time. Then it could have been considered.
Yes.
Under which provision?
Or another, this civil procedure code.
No, that is
No,
expressly barred by
But,
the Act
but
statute.
can you see, under the rules of our High Court, civil procedure does not apply to the writ proceedings. But
Yes.
Rule 53 said that notwithstanding contained in the civil procedure code, procedures may be followed.
Correct. So there is no such provision here. That is what we are trying to see, that the procedure must be followed or may be followed. Show us. Otherwise, we are trying to understand how the tribunal will appreciate or grant a substitution.
But then if somebody died,
Yes.
then how the tribunal will grant a relief against a dead person? Assume for a moment there is no such procedure.
Yes.
Under the rules. Yeah. Hmm? Dead person register order হবে? uh, substitution. Push. Just. Central Administrative Tribunal Procedure Rules 1987, Rule 18. That's a difficulty. But all along, yeah, this is followed. Rule 26, sub rule 11.
27.
Rule 28. Rule 28, sub rule 11. Ten and 11. Received the application for substitution of legal representative of the disease parties during the pendency of the application. Receive and dispose of the application for substitution and accept where the substitution would be involve setting aside and order and amendment. And same power vested in a high court. Application for substitution, setting aside amendment with the logical register.
Within time.
Within time. Beyond time, as per civil procedure code and the rules of the high court. High court, not by the bench. Yes. Receive an application for substitution of the district during the pendency of the applicant. Receive an but a parent act for that kind excuse me, madam. What is there is a parent act, administrative tribunal act. But in that event,
Rules framed under the power under section 35 of the Act has been exercised by the rule-making authority.
Authority, central government.
Now the same rule-making power is exercised by two authorities. Central government exercises that rule-making power. It incorporates the time limit of 90 days.
Okay.
Your state government exercises the power under section 35. It does not. It in specific terms says during pendency of the
No,
application.
This power has not been vested to the central government. State government, kindly see the first page. First date, notification dated 21st December 94. In exercise of powers conferred by subsection 1, read with clause D, E, and F of subsection 2 of section 70, the central government hereby make the following rules.
So whoever under section 35, the government says whoever is the competent rulemaking government authority says in the central government there has to be a time limit. In the state government, it has to be during pendency of the application.
But that is not applied because he has withdrawn the application.
All right, he has withdrawn the application. That we'll consider. That he has
But
already.
if application is withdrawn, then no application was pending. Then what would be the effect of it?
No, then what would the effect?
Consequent.
The consequence of such withdrawal on one, the person who has withdrawn, and two, the person who has not withdrawn. There are two things. So first, the issue is one person has withdrawn,
Hmm.
who was required to make a substitution. The other thing is the person who was not required to make a substitution, he has not withdrawn any case. He has pursued his matter. You never objected to his continuing with the proceedings. That how he is continuing, you have argued the matter.
No, I'm only about the
Where is
application.
that application? Where is that objection before the tribunal? In the order. There is no such objection either recorded by your side, nor there is any application filed thereafter that how they can pursue with the matter.
No, what kindly see, but we are objecting about that.
Let us see your objection.
No, our objection is all so far as
They didn't file any objection.
objection.
You have not even assisted us with reference to the rule or anything. Please take your seat. We were expecting you to assist. Yes.
But just last part one. After hearing both learned advocates and considering the facts of the case, I agree the applicant in this matter is similarly circumstantial the applicant way number. If the order direct the respondent number 4,
Not even a whisper of objection from your side.
No, that has not been recorded.
That's not there. We have seen, therefore we are saying these things you cannot improve. We understand that.
Yes.
Now come to the rule 4.5. That's at 5, rule 4.5a.
Yes.
Obviously that satisfaction was there. Otherwise it would not have remained pending for more than a decade before the tribunal. 5a, and then accordingly they must have paid the court fee in the proviso to sub rule
Yes,
7.
there is no dispute about it.
So therefore, when the more than one person joins together and files a single application, it is this, if it is satisfied, having regard to the cause of action and nature of relief prayed for, that they have a common interest in the matter. So this satisfaction you cannot deny
At this stage,
at any stage, because if at all it was to be done at the very initial
at the
stage,
very initial stage.
which has not been done. So therefore, the withdrawal of the matter by the applicant number 1, whether it will have a consequence on applicant number 2, we'll have to see with reference to these provisions.
Yes.
Now, whether he was required to file a substitution within a time when you are trying to import the requirements under CPC, which are expressly under section 22, it says the tribunal is not to be bound, and the central government has framed a rule saying that the application for substitution may be made during pendency of the application. Whereas in the same central government, while framing the rules for the central administrative, says 90 days.
90 days.
So that is a very conscious omission.
Yes. There are conscious omission or omission on the part of the.
No, that is a reflection of the legislative intent.
But we do not have any hands, or we do not have any right to say.
Correct.
State government has nothing to say.
Correct.
It is for the central government to do.
Yes.
If any defect is there or omission is there.
There is a question of defect.
No. What is the omission
You
or
have never assailed this provision. You are,
No, we do not have a right to challenge.
therefore you cannot do it now also. You have to comply with the rules. This is under the rule making power exercise under section 35 of the
Yes.
Administrative Tribunals Act by the competent legislative authority.
Can you see?
Can you lay your hands on some precedent or decision
Yes.
in this regard?
Very,
It's an interesting issue.
yes,
to be understood.
interesting
Therefore,
issue. When matter file was placed before me, when I have,
you have raised a very interesting issue, but we want to decide it. We have not made up our mind, but looking at the rule provision, why the same rule making legislative authority or the authority has has couched the section or rule regarding substitution in explicit two distinct terms for the two distinct tribunals. Therefore, there is no parity between the two in the rules on this, or at least on this aspect. So what will be the effect? Withdrawal, of course, comes later. That we'll see. And
that there cannot be a vacuum in the law. There cannot be a vacuum in the.
no, there is no vacuum. It's very clear during pendency of the application.
So that indefinite period.
Yes, indefinite. The Tribunals Act is to be applied. If the letter and spirit has to be applied, it should be very expeditious. If it is not, if it continues and lingers for a decade, then consciously the rule making authority says for this the applicant should not suffer during
No,
pendency of the
If
application.
that argument is accepted, then why the central government making the rules for the central administrative tribunal 30 days and 90 days?
That is not a question before us. That is not a question. We see the distinct, there is a very distinct provision in this regard between the two provisions. Therefore, this must have fallen for consideration in some case. Therefore, we are saying, have you seen any judgment on this point?
Whenever some time to me, whenever again I will try to search my own.
Third learned counsel
way.
for the petitioner as well as the learned counsel for the respondent. The learned counsel for the petitioner Please examine the issues.
This proposition of law.
No, it is interesting. We should consider this. We should.
And so far procedure is law is concerned, there is no judgment of court. Or only on different states have different rules.
Correct. No, whether different states have different rules because it is the central government framing the rules. We don't know. We'll have to examine. But we are only concerned with the rules governing this state at the moment.
Obliged, Lordship.
Item number 12.
The parties full stop. There is also no prayer for accommodation. List on give the date of Monday. Orderly to pick up the pencil. All the next.
Item number 13.
Item number 30, Lordship, I am for the petitioner led by Mr. Honorable Lordship. The matter regarding Lordship shortfall of service, Lordship.
Qualifying service
Yes, Lordship.
for pension.
Lord-
What is the shortfall?
Lordship, shortfall is 3 months, Lordship, 10 days.
But there is a
Within-
provision giving a discretion for
Yes, last occasion,
6
Lordship.
months.
No, Lord, 6, yes, Lord, 6 months. Yes, Lordship.
— 35 days.
35, yes, Lord, 3 months, 10 days, Lord. 35 is a similar order, Lord. The High Court has passed the order, Lordship. The last order is also
3 months, 10 days.
3 months, 10 days, Lord. Lordship, ওটা দেখে নিন। তো নোট করা যায় না। হ্যাঁ, তবে তো উনি 35 সিমিলার অর্ডার আপনারা পান। আচ্ছা, আমি বুঝতে পারলাম যে 35 পয়েন্ট বললাম, তারপরে এই অর্ডারটা আমি এদিকে চলে আসি না।
But your lordship had seen this order, but this matter was heard at length on the last day. And rule 36. This is rule. কেন আনে? Service rules টা।
DCRB.
Service rules নেই?
No, this DCRB. That West Bengal. This is central government. They have not given the circulars up to date. Still, ask them to give the circular up to date.
আপনি আপনার কপিটা দিয়ে দিন।
Where is it? Come up here, see where it is.
Take this one. इसको लीजिए।
One more copy.
Only one copy.
Why? In the meantime, they have got another copy. Ask them.
দিন আপনি। এটা যচ্ছাবকে দিন এই কপিটা। Take this one.
Rule 36.
Yes. কপিটা আনুনি কেন বাবা?
They got. It's not that.
একবার ফোন করে দেখো পেয়েছি কেন, তারা তুমি চলে যাও। নাম জানো না? অনিতা সাউ। এই যে স্টেটের বাজারে পড়ে। অফিসিয়াল আমার অপশন রয়েছে নোট তো আগের গুলো ডাবল দিয়েছে।
Right.
Does the DCRB rules prescribe a separate or separate eligibility for gratuity and pension.
Gratuity and pension, everything has been discussed in the disagreement.
So does it prescribe a separate qualifying service for gratuity and separate qualifying service for pension?
If he is entitled to pension, he will get pension.
No, that is all right. But even if he is not entitled to pension, he will not get gratuity.
No, gratuity will be double.
No, what is the meaning of this provision? Let us see.
Can you see the pension? Definition of pension at on a rule 7, then Banada 2,
Yes.
then a small f.
Which one?
If you logic can you see chapter 2
Yes.
definition,
Yes.
then can you see subgroup 2 for the purpose of family pension, then F. It comes under the purpose of family pension. Pension except for the pension used in contradiction with gratuity, pension includes gratuity. When
No, pension includes gratuity, but does gratuity also include pension? Everyone who is entitled to gratuity, he will be entitled to pension.
if he gets a pension, he will be entitled to gratuity.
That we have understood.
But if he does not get a pension,
He will not get gratuity.
if he is not get the pension, then he will be get the double the gratuity.
Therefore, that is then the qualifying service, even if he is not getting pension, for getting gratuity, what is the qualifying service? Perhaps it is 5 years.
5 years.
Perhaps it is 5 years.
Because of the pay.
So therefore, for gratuity, 10 years is not required. For family pension,
Family pension is only 1 year service.
1 year.
1 year service.
So therefore, family pension, he has to have 1 year service.
In the confirm service.
Yes, obviously confirms. Gratuity, he has to have 5 years. For pension, he has to have 10 years. Now see Rule 36. Now read the note below Rule 36.
But can you see the note?
That is what we are saying. Now read the note. What
No.
does it say?
The deficiency should not be condemned.
When it should not be con.
Deficiency of qualifying service of 10 years.
Is read it.
Efficiency should not be controlled with the view to make the minimum prescribed qualifying service for the purpose of death gratuity.
Gratuity and
Death
family pension. Yes, death gratuity and family pension.
Family pension.
So it should not be this relaxation power should not be exercised to cover up deficiency for if it is less than 5 years or it is less than 1 year. This bar is not for covering the deficiency of pension.
In other cases,
Yes.
power should be restricted to the government servant joint pay not exceeding rupees 425 per month at the time of retirement or invalid compensation pension.
No, read that to the last also. There also there is a rider.
In other cases,
Yes.
power should be restricted to the government servant
Yes.
joint pay not exceeding rupees 425 per month at the time of retirement or invalid or compensation.
Yes, retirement when? If it is on invalid or compensation. So all these note does not apply to pension. All these are specific. This bar under the note is for family pension, is for gratuity, is for a person retiring on invalid or compensation pension. He is not retiring on invalid. He is not retiring on compensation pension. He is not seeking the condonation of the qualifying period for gratuity. He is not seeking condonation of the period qualified period specified for the purpose of grant of family pension. He is only seeking covering up of the period for pension.
Pension, regular pension.
Correct. So this note
Then,
does,
but can you see the
this
power?
note has nothing to do with regular pension.
Can you see the power? Can you see? The power of the government to condone deficiency in service upon any condition which may think fit to impose. The government may condone deficiency of 6 months service in qualifying service or something.
May what? Upon any condition.
Any condition.
So what is the condition you tell him?
The condition is under the rule 3 capital A of the WBSR.
Rule 3A,
Yeah, I just give a WBSR.
BSR. What is that?
West Bengal
Service
Service Rules Part 1, 71. Power left discussion led to the governor.
Oh no. This is the service rules.
Service rule.
Yes. There is no interpretation required. It's not a question of interpretation. It is what condition you want to impose.
It is for the governor, not
No,
by the
no.
executive.
That interpretation is not involved. There is no question of any interpretation. It's only a question of the condition. And when it says any condition, what is the meaning of any condition? Does it mean a condition which ultimately results in total denial of the claim? Your discretion is only to impose a condition. What is the condition? You tell him and you give him the qualifying service. You may say that for this period will not pay you salary. You may say things like that, but you can't.
But that we have said so in the written order.
Let us see.
83. 83.
Start that 80.
Not a single line has been spelled out.
Where we don't find any condition, you have flatly rejected that it cannot be done. Okay, we
But
don't-
so long the strategy is there, but he has no power to go so beyond the power.
And what has the tribunal done? Just affirmed the order.
Yes. Page 87. And the judgment of Justice Tendon was also placed there.
Of justice Tandon without availing the benefit of judgment of the secret, larger than judgment of the Supreme. Justice Krishna had.
You relied on which judgment before the tribunal?
Correct.
You relied on which judgment before the tribunal?
Well, just now my juniors, page 64 to 71. No, sorry, it starts from 77. Page 77. Same department, same thing. There was a delay of
35 days.
35 days. Condoned. And the government has complied with the order.
Only on 35 days.
35, 3 months, doesn't matter. Below 9 years. 9 years, 6 months.
Whenever people will come, then we shall have to pay pension.
Where is the qualifying service for grant of family pension?
The 36.
Chapter 10 is regarding gratuity. Which one? Where is the family pension?
Pension. Yes, but at chapter 9, qualifying service.
Chapter 9.
Yes. This is rule 9. Sorry, I'm sorry, rule 9 of the death cum retirement benefit rules.
Rule 9.
Rule 9 says qualifying service. Rule 17.
Rule 9 is recovery of sum due to government from pension.
But rule 9 of just a second.
Rule 17.
Rule 9 speaks of rule 17. This is 1971 rules.
Chapter chapter 10.
Chapter 10 is gratuity.
Yeah, they kindly say they are practically 101.
101.
101. And 102.
But at the recent order, page 84, speaks of the finding. Kindly says, as per rules, the minimum qualifying service required to receive pension is 10 years. Page 84.
What is that? Part of the order?
Part of the recent order.
So you are assailing the recent order or you are relying upon?
No, I am assailing the recent order.
Then
But
why do you want to show us from the rule? Where is the prescription? Why should we refer to an order which is impugned before us? Family pension starts at rule 101.
Okay. Family pension.
Mr. Mukherjee, this is, it is available.
No, it's
This
not available in the market. Government publications.
you give us,
Keep it with you.
please give us. No, if you want, you can give us a photocopy, whatever.
Yes.
If you,
Tomorrow,
please give us 2 copies. You get it done. You get it done and return it to him tomorrow. 2 copies. The entire thing. We'll get it done and we'll return. We have seen for family pension, it is admissible even in less than 1 year.
but if somebody,
A proportion, 30%.
just for example, if somebody joined on medical exemption and returning, signed the accident register, returning from the office, he died in accident, he'll get full pension, family pension.
No
Because
other,
at the time of death, he was an employee of the state government.
even otherwise, there is a provision which says he will get proportionate, even if he is less than 1 year. It is the same. It's not the same.
If somebody joins after medical exemption and police verifications, join and before returning to his house, if death took place, he will get full pension.
It's not the same. Compare with that. You see if you have it. See if we have it, if we do. Do contract. You please see, read this paragraph. At page 2 of the judgment,
Second
at
paragraph.
page 78.
Second, the identical.
Third paragraph, in the instant case The pension was denied not on the ground that if the deficiency is condoned, he would be eligible. He would be, it's very difficult to read. He would be not on ground that if the government condones the deficiency, the qualifying service of the petitioner would not be eligible. If it was denied, it was denied relying upon which inter alia shows that deficiency could not be condoned in the case of employee drawing pay not exceeding 425 months at the time of retirement on invalid or compensation pension. So the same thing the court has considered.
The delay in this case is 26 days only.
Yes.
In this case, the then Malad Kaniki,
In this case, now the next line is very important. In this case, in the instant, it is a case of pension simpliciter. It is not a case of gratuity. It is not a case of family pension. It is not a case of someone who's retiring on invalid or compensation pension. So note has been considered.
moreover, the said note in our bid cannot be whittled down to the effect the substitution of clause 7A of the rate with circular dated in other rules, not in the DCRB rules. In the education department.
Same proposition.
No.
What
It's a
rule?
rules of framed under Article 162, not under 309 proviso.
Where were you reading? Moreover. Oh, acha. Moreover, the said note in our view. This is what you are saying.
Yes.
Circular of 2nd February 2009. What is it?
This is with regard to the education department.
This is not, that provision is not applicable here.
But in the education department also, one of the same principle applies. And the state preferred an appeal before the division bench, challenging or assailing the said order, where pension was awarded. This order has also been annexed in this petition. The state failed. This 425 rupees 425 was discussed by the honorable division bench. That is also one shortfall of service.
In this case, perhaps they were considering the effect of the circular.
Yeah, circular of education department.
So that is not applicable here.
Yeah.
Not applicable, but of similar nature.
Field of resolution is different. 162 in the education department and here 309 proviso.
No, nobody is on the competence of the rule. It is made under the proviso to rule Article 309. That is all right.
Yeah.
We are not saying that the rule is incompetent by an incompetent. Nobody is saying it is not binding. We are trying to understand the rule as it is. Does it give you the power to reject the condonation if it is within 6 months?
Well, because the language is may.
Yes, so that we have understood. But may is what? May is in only respect of the condition to be imposed.
Yes.
What condition you will impose, that is the only discretion you have.
No, that has to be read with the rule 3 and 3A of the WBSR, which has been relied by the
Read with?
Rule 3 and 3A of the West Bengal Service Rules. Framed under the same.
3A has no application here.
Exactly.
3 and 3A has, that is for interpretation of the rule. We are not asking any there is no interpretation of the rule.
Relax any requirement.
Yes.
Relaxation power is based with the governor.
No, there is no question of any relaxation.
Relaxation has to be up to 6 months. That power can be
that the governor has already said by framing a rule under proviso to Article 309, that need not go. That is the governor's rule framed under the proviso to Article 309. He has already said how that discretion is to be exercised. It is not a question that there is no provision, the act has to be or rule has to be made for rule 3 of which
3A.
3A of the West Bengal Service.
Give the service.
Consultation with the finance department that has been complied with. And that rule 3 is the entire power has been given to the governor. Relaxation power.
All right, we'll consider rule 3A.
Yeah.
No problem. Just give us a copy of the rule. We'll take a copy and then we'll give that back to you.
Well, your lordship, as your lordship has this book has this rule.
Yes, we are looking at 3A.
3A.
Nothing in these rules shall be construed to limit or abridge the power of the governor to dispense with or relax the requirement of any of these rules to such extent and subject to such conditions as he may consider necessary for dealing with the case in a just and
equitable manner. And what Mr. Mukherjee is saying regarding proviso, Tara Singh's judgment, Tara Singh's judgment has been dealt with by the Honorable Division Bench at page 65 of the writ petition. Page 65, second paragraph. The function of the note is to provide procedure and to control discretion. The real purpose of the note is that when rules are silent, the notes will fill up the gap. That is the observation of the division bench, considering Tara Singh. There is no ambiguity. Page 65.
There are two things, power of relaxation and note is different. Power of relaxation. Relaxation is not mandatory. It's a discretion of the government.
Who wins?
And regarding the note, what is your submission? That note
But no,
regarding
it's
the
a part
note,
of the statute.
yes, it is. Nobody is saying it is not part of it. There is no dispute. He is not saying it is not part of it.
But in
I
this
cannot.
case, first we shall have to go to the parent statute, rule 36. But it is the discretion of the government. May
That you have said, relaxation is not mandatory. It is at the discretion of the
and
government.
government keep things that
Only if the governor thinks it can be done.
Yes.
This is your.
but the executive cannot override the governor because all executives are below the governor. But
Yes.
he is the supreme authority because delegated power by the president. When Supreme Court said eyes and ears of the president.
For a state government employees, that concept will not apply. For a state government employees, that concept will not apply. For state government employees, the concept as contained from Article 163 to 166(7) that will apply. So both these submissions we'll consider. West Bengal service rules. Rule 3A and relaxation is not mandatory, declared but discretion of the government. Just give us copy, let us get a copy of the rule. Judgment.
Yes. Great.
Yes.
Item number 14.
Yes, ma'am.
My lord, in this matter, my lord, I am appearing on behalf of the respondent. If your lordships kindly see your lordship's last order, that is, my lord, 12th November, your lordship's recorded that I have submitted, my lord, it may kindly be, my lord, corrected.
Judgment has been passed.
But my submission has been recorded. This was, my lord, submitted by my learned friend. As I am appearing on behalf of the respondent, and my lord, your lordship's recorded my name as, my lord, appearing as petitioner, but my lord, I appeared on behalf of the Union of India.
That is obviously a error.
That may kindly mark. I pointed out to your lordship, my lord.
So what happened? That judgment has been delivered.
Yes, my lord. I'm placing it in larger interest because of the fact, my lord, Pan India, in some benches only administrative members are there. In Kolkata bench, 2 administrative members, 1 judicial member. 1 administrative member after this order is sitting idle. I humbly pray that issue may kindly be decided for once for all.
In your case also, single judge.
Yes. I beg to place one judgment, my lord, of this coordinate bench of this Honorable High Court, which says make some observation otherwise, so far as Central Administrative Tribunal is concerned. There is some contradiction. This is against the order of the State Administrative Tribunal.
No, how this will apply? This is for the state administrative.
No, Administrative Tribunal Act is on.
That may be different, but the government has issued rules, instructions which are different for both the tribunals.
Yes,
So
that's what this judgment has considered, that in case of Central Administrative Tribunal, there are separate rules. Chairman has been given the power. Chairman has made the provisions for single bench classification of cases to be heard by single bench. In State Administrative Tribunal, it is not there.
Yes.
So this judgment says that set aside the order of the State Administrative. But second page, you will kindly see. Second page of this.
Yes, so
that's why, my lord, these observations are different.
that is what without reading it, we have told you that it has to be different.
Yes.
Here the chairman has
But
power.
these decisions have been rendered in case of Central Administrative Tribunal. That's and single member, admin member sitting singly cannot hear.
Which judgment has?
Other judgments I've given. Latest judgment, latest decision.
This
That
one
is a-
that you have just given.
Yeah, just given. No. Before that, WBC 221 of 2024.
So 221, that is why we are saying it can be remanded for the division for two judgments to hear.
But my visit to your lordship, this decision, although regarding a state administrative tribunal, but some observations are there regarding amendment of section 5, subsection 6.
Which judgment? This
Yes, last judgment which I gave.
the case of Mithu Mandal.
Yes.
No,
Yes.
this doesn't apply to your case. This is deciding an issue arising out of the state administrator.
No, that is true.
This will not apply to your case. Between these two judgments, this will hold the field.
But issue may be settled, my lord. Otherwise, we are in difficulty.
So what is there to settle if the chairman has issued a circular or an instruction that it can be placed before a bench of which is being presided only by one member, and you have the option to object at the very first instance. If you don't do that, then
Yes.
what is to be done? Where have you raised the objection? On
No. That in this case,
Yes,
Bachchan Pandey's case,
yes,
WBC 221 of 2024,
yes,
both sides gave consent. I also gave consent.
yes,
Union of India also gave consent.
yes.
I placed it before the honorable coordinate bench. The bench said no, consent does not confer jurisdiction, so set aside the order,
Correct.
saying that it is remanded to the tribunal for fresh hearing by division. Fresh hearing. It was in my favor, this decision.
Yes, that we have seen.
Union of India,
Where is the judgment of Jayanti Chakrabarti?
yes. Jayati Chakra.
Jayati Chakrabarti.
Jayati.
In this case, also administrative member has decided.
Yes.
Administrative member has decided. Same order has to be passed.
But one thing, my lord, I was enjoying interim order till the disposal before the landed
That, my
tribunal.
lord, I have, my lord,
No, just a minute,
objection.
let me finish. I was enjoying till the disposal. After that, I approached this Honorable High Court. The coordinate bench of this Honorable High Court also granted interim order.
What is the order which is impugned?
Yes.
What is the effect of the order impugned?
Transfer.
Transfer.
Well, a person is, my lord, staying in 23 years out of 25 years.
That is on merit.
And my lord, on administrative reasons, my lord, we have transferred him one place to another. Now, my lord, there was a direction, my lord, to submit a representation to us for reconsideration. She has also exercised that, my lord, liberty granted by the tribunal.
After the interim order passed by this Honorable High Court.
No, not after the interim order.
Yes. The interim order was passed by this Honorable High Court on my lord 7th February.
7th February.
2024. In this case.
And when did you submit your application?
13th March. While in Mumbai for the treatment of my husband.
13th March. There was some subsequent development you were saying the other day that some new ground has also come up.
My husband is suffering from cancer.
That also you have brought to their notice.
Yes, yes. That was considered by the learned tribunal also. Recorded.
That is not a fact subsequent to the order of the tribunal.
No, no,
So after the tribunal, there is no fresh ground.
no, no.
Somehow I remember that you were saying that some new ground has been.
No. Only this decision has come recently.
So why did you come here when they have the tribunal had already directed?
Because of the fact, my lord, the tribunal upheld the speaking order which said that my mother is not my dependent. As you may remember, I placed the document that my declaration. They in the speaking order they said mother's name is not in the declaration of the dependent in the service record. That was upheld by the learned tribunal. Here, my learned friend on the last occasion admitted, said that no, her mother's name.
I have not said anything.
Yes, you
No,
said.
I have not said anything. So my learned friend is submitting.
I am
what have
placing
said.
that document. Yes. That document I have annexed already.
You are here since 2006.
Yes. 16.
No, you are here since 2006.
6 means
You are at this place of posting in Kolkata since which year?
yes, it's 2006. Yes.
2006.
Yes. Yes, that is true. But they rejected on two grounds that you don't have any certificate of any illness of anybody in your family who is suffering from terminal illness. Secondly, your mother who is handicapped, she is mentally handicapped. Her name is not in the service book as dependent. Now, Lordship, you will Lordship kindly come to page 120 of my writ petition.
No, that is of 2017.
Yes.
That is not a declaration in your service record.
Yes.
That's of
Service record
2000
every time I have to declare.
That is of 2017, sir. What is the date of the transfer order?
18.
Yes, that is of
After before that I submitted.
Yes.
Because my lord, we have to submit time to time.
When are you due to retire?
My age is 57. I crossed 57.
So you want to exercise an option of staying at the same place throughout your career.
That is to be considered by your lordship.
Just what we are considering, it is a very unique circumstance.
But now this decision,
We have seen the certificate of the disability also that you claim.
Yes.
Almost every person in their nearing 60s, they has this kind of a problem.
no, I
Then
cannot,
everybody
I
should
cannot
be-
walk without assistance.
Then everybody should be peculiar.
And I placed that decision, my lord, personally considered.
Yes, we will consider. If you want, we can consider everything on merit, or if you want to go there in terms of this order, we are asking you.
Yes, my
You
lord.
want- As you like, we'll decide accordingly.
No,
Because
logically,
you have placed this last occasion, you said this matter was pending.
no. This was disposed of just before that day.
Correct. The judgment had not come.
No, no.
So we adjourned it. Now it is here. It says that the tribunal is to decide in a duly constituted forum. You can go there if you want to rely on this,
My lord,
or we can.
that
consider it.
that issue, if your lordship kindly decide,
What issue?
whether administrative
Huh?
member sitting singly,
No, what is there to decide? There are two coordinate benches. Why should we unnecessarily go into that? They have both held that it cannot be done. What is to decide? There's nothing to decide.
then lordship may kindly remand.
Nothing remains to be decided. And the tribunal has asked them to not transfer you till they have passed a reasoned order. Still, you have come to the High Court. Unique circumstance. As if you have a right to continue in that place forever, it seems like that.
Not me, my lord. There are several parties.
Hmm?
There are several parties. I was under protection.
Ah.
Before the London Tribunal, I am under protection before this honorable court also.
For that, you take the plea of the tribunal's order. But when the tribunal says not to transfer you without passing a reasoned order, then you come to this court.
Because that issue, that will create my problem, my lord.
Okay.
My mother, if mother is deleted, it is held.
You want to dispose of?
Yes, my lord.
Yes, heard learned counsel for the parties at the very outset. continue. What is this? You have to make some submission.
Urgent.
The repetition is disposed of according. Yes, you will get it. Just send this immediately in lunch.
Item number 15.
I am for the petitioner, my lord. I'm praying for 1 week adjournment, my lord. So supplementary evidence is required to file.
23rd September 10th.
Yeah, lord. Why should the lordship direction petitioner join in the office?
Learned counsel for the petitioner seeks Yes, next case.
Item number 16.
This matter
I'm for the respondent also.
for the petitioner. It is a modified assured career progression, which allows 3 maximum promotion. And the respondent did not tender the technical resignation when he was temporarily appointed as fitter. His on initial date of appointment was 5/6/1981. He was therefore. Is any reasoned order passed rejecting the claim? Is there any reasoned order passed rejecting the claim? No. No. My lord, he did not claim at that time. There is a reasoned order 22/11/2018. Where is that order? There is some reply under RTI of 22/11/2018. The RTI is 80%. It was rejected. The RTI was rejected. What is that? Show us. Where is it? The claim, the RTI. You have sought quashing of the RTI reply of 22/11/18. Where is that reply of 22/11/18? I have not sought. Sir, please come to page 2 of the impugned order. What is your prayer A? Page 2, page 2. Yeah. Yes. RTI reply bearing that passed by the respondents. It is the prayer of the petitioner there. I mean, respondent hearing. I am the petitioner in this matter. There I was respondent. Hello. Yes, yes. This is the order I'm challenging, I have challenged, and this is the
Alice? Yes, yes, yes. Alice? That is as page 41, in which they have denied that the third MACP. Well,
No, I have challenged this order only. That is the reply of the RTI. My lord,
yes.
my lord, my lord.
Yes.
Lordship, if you may, kindly comes to page 72. There is a in one before the last paragraph, in case where an ad hoc promotion is followed by regular appointment without break, the option is admissible from the date of initial appointment or promotion to be exercised within 1 month from the date of such regular appointment. This is the fundamental rule. Is if you may, like Lordship, be kindly be allow me to refer to page number 72, where the fundamental rule has I have annexed the one paragraph just before the last one. That is, in case where an ad hoc promotion is followed by regular appointment without break, the option is admissible at that date of the initial appointment or promotion be exercised within 1 month from the date of such regular appointment. My lord, the date of appointment is 5681 in this case. In this case, as fitter, as temporary. That is the question. That is the question that the promoted. Hmm. Right, my lord. My lord. My lord. My lord. That is my case. My lord, it was he has not tendered any technical resignation which is required for a fresh appointment. It is a standard operating procedure. My lord, it has not been raised. He was allowed the benefit of past service. My lord, he has not tendered resignation, so his date of appointment remains the same. My lord, it can be inferred. My lord, his promotion was always calculated from the date of appointment, that is the first date of appointment, that is 5681 in all cases. Had he been deadly thing will not help you. We are asking you to show from what is the basis for saying. Saying it 3 times does not make it better. You have to show what is the basis for this submission. We are asking you, show us. Service. Where is your WS which you have filed? It is not in the WS. Did you file any WS or you didn't file the WS? No information.
Page. So after he was selected as assistant development officer, he has got one promotion and one upgradation. My lord. Whether he will get the third or not will only depend on this fact that it was a promotion or not.
My lord, kindly looks at page number 52. His service book,
52.
52. Uh, 52 and 54. All right, 52 he was transferred.
My lord, there is one mentioning, my lord. My lord,
Yes.
there is one mentioning from Port Blair, my lord.
Why are you mentioning at this point? You should have mentioned in the morning.
My lord, I will mentioning morning in the wrong bench, my lord. This in court number 11, my lord. From that, my lord, he asked me the suitable bench is court number 4, my lord, honorable court.
Yes, what is it?
My lord, there is one impugned order of the CAT is passed on 21st of November, my lord, which
Yes.
is paid the interim order, my lord. Against that, my lord, we came in this writ petition, my lord.
So,
Heard this matter mentioning it tomorrow, my lord.
you want to mention it tomorrow?
Yes, my lord. For
You
tomorrow.
mention it. Who is stopping you? You can mention.
Grateful.
Yes.
Mm.
Yes, service. It is page number 54, wherein there is no reference of terminating one service from another and starting one. There is no question of nothing is mentioned about termination of that fitter. But only in page number 54, that is joint duty as ADO is referred. Had it been a fresh service, there should have been a mention of that. '82. 83 he has joined. Page number 54, last part. Yes. Hello. That notification.
May I submit? Since my learned friend forgot to annex the reply and rejoinder, I have filed a supplementary affidavit annexing those where your lordship will get that particular notification. I'm seeking leave to file the supplementary affidavit annexing both the records. Yes, it should be there. It ought to be there in a petition. It was issued in the Employment News, Malik, Directorate to Gobar Gas, Employment 8283 slash date. Get this lordship.
My lord. Some documents are there which has not come to me. I have already informed the department.
That's part of rejoinder. If your lordship allow me to place the fact that
Fundamental rule 22, where is that?
That is at page number 72.
72.
Page 72. And page 73. Subclause B 1.
Look at his pay fixation, my lord. Come to page 54. At the bottom. His pay has been fixed at the minimum scale of the pay to which he has been appointed. That means it is a fresh appointment. Otherwise, in terms of FR 22, he would have to be placed in the next scale, next level in the scale by giving him an increment by virtue of promotion under FR 22.
And 53, my lord, just prior to that page, it's clearly stipulated that it is officiating temporary. My lord, the friend has pressed the 54, my lord, 53, that is downside. Officiating temporary, 8/9, 1983.
Yes, but this is just 20 days after that. This entry that we are referring to, it is just 20 days after. It is at the during that very same time. He has gone on temporary basis. They have worked out the admissible dues. They have fixed his pay. This is all part of the same transaction within 15-20 days has been done.
It was a fresh recruitment, duly advertised, open recruitment.
There is no resignation which is necessary for MSP.
That we don't see. You have not pleaded any such. This is not a fact pleaded by you. You have accepted his appointment. The appointment has been offered on 1783. 1783, he was declared, he was given the appointment. That order is also at page 60. Now see how he has been addressed at page 61 in the bottom. There is no reference to his earlier post. Plus the terms and conditions of page 60 also. There is no link with his past service. See page 60, no link whatsoever. In fact, even though he is in government employment, He is employed under the central government. He is again asked to even go for medical test. All the formalities of a new. See clause
lord.
6.
My lord, there is one thing that in the advertisement, I'm not able to show the advertisement, but there was clearly relaxation was granted to already employed, already temporarily employed person. He was he was one of those category.
But he had not availed any benefit of such relaxation.
Yes, he has availed that's a relaxation of 2 years minimum age, minimum qualification. He has
What was the maximum age for appointment? Under
30
the
years, I
advertisement.
suppose. It was 30 years, I suppose.
It was 30 years. No, there is a categorical finding of the tribunal that he has not availed any benefit of relaxation. Show us what benefit. Where have you said that he has availed benefit of relaxation? Show us.
No age limit in the case of the candidate who are in service of the commission.
Okay.
Clause 11, my lord. No age limit in the case of the candidate who are in the service of the commission. That is the open recruitment. And where this is the clause, those who are part of the commission, they no age limit. But so far as the conditions are concerned, my lord, we have not taken any benefit of being a relaxation of being a departmental candidate.
There is a specific finding of the tribunal.
Yes. And if your lordship will go into the merit of the granting of the ACP, the first ACP, that symmetry of date is coming within the zone of consideration. This is the new appointment and they have given the first benefit. That is 2007 with effect from 2011. So first 12-year block, he got the promotion, he did not get the ACP. The second block, he got the ACP, and the pilot, we will see that one document only. It will suffice. Kindly come to page 32, your lordship. 32, my lord, if your lordship will peruse that serial number 16, the name of the petition, the name of the respondent here, my lord. At the third bar, that is second upgradation with effect from 8/9/2007.
Page
32.
32.
Yes. That is the order of the first ACP.
So 2007.
Yes, well,
So if you go back 12 years, it becomes 90.
I'm putting the date palette. In 1983.
95.
Yes. In 1983, he joined the ADO. In a first block of 12 where he got the promotion for the post of DO. Therefore, no upgradation. In the block of second, he got the ACP in 2007. And as for the MACP, 10 years, he will be entitled to.
Correct. It is exactly after 24 years he has got. 83 plus 12.
Yes.
95 and then another 12 years, 2007. Yes.
Item number 18.
Got for the petitioner. Lord, I'm praying for not this week, my lord. Serial number 18. Order point.
Yes, last time also you have sought an adjournment. Why? You're not interested in doing this matter.
No, it is not that he is sick, my lord. So he has just requested me.
He is sick.
He's suffering from fever, my lord.
Last day also continuous.
No, my lord. Simply. Kindly keeps it on Monday, my lord. I shall inform him.
No, adjournment is not so casual. We are asking you why. Last time also you have sought an adjournment.
I think it's very. My lord, I would inform.
Have you filed the reply?
My lord, I'm for the petitioner, my lord.
Correct. That's why we are asking you.
But I need to then ask him, my lord.
So you don't know anything.
Yes, my lord. He is the advocate on record, my lord.
Again, today a prayer is made for adjournment. Matter.
Till
19, I am for the petitioner, my lord. Mr. Debabrata Karan, my lord, appearing on behalf of the petitioner, my lord. Due to his personal difficulties, my lord, I'm praying for not this week, my lord. Even last occasion, my lord, there is order for filing opposition. Opposition also not been filed.
Your Lordship, I am appearing for the state in this matter. Your Lordship, before the vacation, there was a direction, Your Lordship, for filing affidavits, Your Lordship. Your Lordship kindly grants us an extension of 2 weeks to file the affidavit, Your Lordship.
My lord, in this matter, I am appearing for respondent 5 and 7, my lord. The state respondents are the answering respondents.
Who is respondent 5 and 7?
My lord, the office of the principal accountant general, my lord.
You have nothing to do. If
Yes,
they,
my lord.
if they count his service, you will issue the PPO, otherwise you will not.
Absolutely, my lord.
Opposition is not required. Tell us, what is your case?
Mr.
74 to 76, there is a break in service. So therefore, what are they to say? Show us that there is no break in service.
Mr. Karan, my lord,
Who is appearing?
Dr. Karan, my lord. Dr. Devobroto Karan, my lord. He was, I have instruction as I have instruction, my lord. He was mentioned before your lordship on Friday for this matter adjournment. My lord,
Not today.
no, my lord, not this week.
In the meantime, Miller, so if lordship so Miller, kindly extend the time to file our affidavit. Because there is prior direction is there, Miller, so we shall file thereafter, lordship will decide, Miller.
Tribunal matters for
Yes,
what?
I know, Miller, because the coordinate bench has passed this order, Miller, that's what Miller, I'm saying.
You are still not prepared, otherwise you have not done anything. Since September, you have done nothing.
Yes, Miller.
2 months has
We
lapsed.
have sent to the department, lordship knows the problems is, Miller. The person who is dealing with these matters, Miller, suddenly he has changed to some other departments. So, Miller, that's what, Miller, we are facing some sort of difficulties. But if lordship give me fortnight time, Miller, we will prepare and, Miller.
Don't you file it within a week?
Lordship.
Item number 20.
What time for the petition? On the last occasion, my lord, the Honorable Coordinate Bench, my lord, granted me liberty to file a supplementary affidavit, my lord. May I file it, my lord?
Why? For what?
My lord, the scheme, this is a case for compassionate appointment, my lord. It has been rejected, my lord, in view of a rule of the government, my lord. My lord, the rule has underwent an amendment. That amendment, my lord, was not annexed to the petition, my lord. The amendment, my lord, I have brought on record by this supplementary
The
affidavit.
amendment was considered by the tribunal.
My lord, amendment was not considered because, my lord, the ground for rejection is, my lord, that the petitioner was not measured at the time of death. Now, my lord, that law has has been amended, my lord. This says, my lord, in case the application is made prior to 5 years, time has been granted.
What is the date of death?
Date of death, my lord. Date of death, my lord. 3rd of November 2013.
And when did you attain majority?
2016.
And what is the time? What is the date? Give us the date.
My lord, 15th of November 2016.
1-5.
My lord. My lord,
So more than 2 years, 3 years.
more than 3 years. Here, my lord, immediately after the death, my lord, the widow made an application for compassionate appointment.
Yes.
My lord, that was kept pending, my lord, for a substantial period of time, my lord.
When did the widow apply?
The widow applied, my lord, in 2014, 9th of April 2014. On 1st of December 2015, my lord, they asked for certain documents. It means my application was under consideration. And thereafter, till 2017, nothing happened. When my lord, on 10th of in 10th of February 2017, my lord,
Yes.
well, due to the illness of the mother of the petitioner, my lord, she made a letter that due to my illness, I'm withdrawing my application. Let my son's application be considered, since he has attained majority at that point of time in 2017. Well, that has been rejected on the ground that the son was not major at the time of death. Well, this law has underwent and changed, my lord, that I have I am seeking leave to file the supplementary affidavit, my lord, to disclose the amendment, my lord. May I, my lord? There was a
That was not before the tribunal. How can we consider it?
but kindly comes to, my lord, the letter of rejection. Touch page 74, my lord.
What is the amendment with that inures to your benefit? Just tell us.
My lord, the mother notification starts from page 13 of the writ petition. My lord, para 6C to the mother notification had underwent a change, my lord. At page 14, my lord, para 6 starts, my lord, eligibility.
So this 6 months has been changed.
My lord, kindly comes to C, my lord, at page 15. And my lord, under 6C, there is a note C at page 16 of the.
That is why we are saying the 6 months has
my lord, this has been deleted.
Deleted.
And my lord, a new paragraph has been added.
When?
My lord, this under in 2016, 1st of March 2016. And my lord, further, my lord, a new clause has been added as para 10AA. This is a new clause, my lord. I'm reading it for your lordship, my lord.
No, we have not taken. We have not taken it yet. If we take it, you will get a copy. Yes.
My lord, this says, my lord, belated request, my lord, the heading. In exceptional cases such as death during action where none of the family members eligible, etc., departments can consider request for compensation appointment even when the death or retirement on medical ground of a government servant took place in up to 5 years ago. While considering such belated request, the 3 members.
How this will apply when your father has died in 2013? How a 16 amendment will apply? That's not a relevant notification. Nothing to do.
My lord,
there may be a notification issued today, so you'll rely on that also.
My lord, but
you do so.
Rejection, my lord, my rejection is in 2021.
That is not the point. The point is your claim accrued in 2013 when your father died on 3rd of November.
But thereafter, my lord, my mother applied. Then if my mother's application was considered within time.
That is a different ground.
But that point I have taken in the writ petition. My lord.
That is a different ground. But this notification, how can you stretch it to be applied retrospectively?
Because
all deaths which have occurred, which claim may be pending, it will start applying.
My lord, only because my lord, the consideration.
What is this new amendment or this new provision which has come must be having a heading that it will come into force with effect from which date? Whether it will be applicable to pending cases or not, there must be a clause.
My lord, I cannot find that, my lord, may I? But the Supreme Court there are judgments, my lord, that the law on the date of consideration.
Show us the judgment.
May I come back with the judgment, my lord? Because the law of consideration here, my lord, They firstly, earlier, my lord, the view was on the date of death, the law as on the date of death. Now, my lord, the law has changed, my lord, the law prevailing as on the date of consideration. My lord,
Which is the judgment.
may I come back with the judgment, my lord? I'm aware of that there has been a judgment, my lord. May I come back, my lord?
All right, you come back.
Took place on November 2030. Monarch and wife was getting pension. He filed an application. He filed an application with the government. I did not press the application because in the meantime my minors are granted the pension. That means one of the he abandoned the right. He abandoned the right.
Can you say so?
No, he has filed an.
If she had abandoned her right, why did you pass the order on 10th February 2017?
When she chooses not to proceed with the application.
If she has abandoned her right in 2016, where was the occasion to reject the case in February 2017?
Because the rejection 2000.
Let us see your rejection. order.
Rejection 2021, man.
21.
21.
Where
Page
is it?
74, man.
Page?
74.
So you can delay as much as you like, and for them the clock has to stop.
No. Can you see page 74 for 17 December 2021. Number sign is directed to refer to memo number such and such, Siliguri dated.
No, there is no decision on the mother's
The
application.
department exclusive in every.
Mother's application, no.
This is rejection of your claim. We
Yes,
are not talking
yes.
about
The
this.
decision 2013 regulation was minor of the date of his father at the date of the valid period of application. Therefore, for amendment of not chosen on compulsion ground is rejected. December 2013, chapter on that page. Starts at page 13.
Page.
Starts at page. Starts at page 14.
Yes,
13,
6 CC you will be written.
At December 2013. Answer P1. Dependent member family mention. On the basis of these modifications, she applied. And one of the after attaining the age of majority, she filed application on 29 June 2018. Page 41. After more than 5 years. কপি দেওয়া যেত আমি দিয়ে দেবো একটা দিয়ে দেবো তিনটাকে বাদ দিয়ে দিচ্ছি তিনটাকে ডিলিট করে দিচ্ছি আর এটা অ্যাড করেছি এটা বলছে 5 বছর পরে মানে বলে কনসিডার করতে হবে চলবে
Yes.
So kindly see
Open
the
nine, open nine.
supplementary affidavit, notification dated 1st March 2016. That is at page 5 of the supplementary affidavit.
Nine is supplementary.
No, we have not gone into the supplementary. We are on the records as they are.
Kindly see the input order page 74.
Yes.
They have considered on the basis of the notification dated 3rd December 2013. That is at page 30. That means on a, within the time specified there. On the time specified there,
What?
time specified therein, another 6 months from the date. Can you see that? Time sheet. Eligibility, text eligibility. Of income condition, date, color.
So the scheme in at clause 10 of your scheme
Yes.
contemplates making of an application within 6 months.
Yes.
If the application is made within 6 months, then only you will treat that it is a case of indigency where they are in need of a compassionate appointment. Clause 12 of your scheme. It says this condition will remain as it is until which time? Till such time a compassionate appointment is granted. This situation does not change. By virtue of clause 12, things come to a standstill and status quo till it is granted. And clause B of clause 14 of your scheme of 2013, just read that. All pending since 2005 have to be examined, even if not given. So this is the purport of your scheme. It does, the scheme does only says to be that application has to be made within 6 months. Now, if the scheme says if they have not been granted, then they have to be considered only if they have been granted, then no change will be on. See, come to rule 12. 12A and B. Clause 12 and when a person has been appointed on compassionate ground to a particular post, this set of circumstances, when he is appointed, not before he is appointed, the set of circumstances which led to such appointment should be deemed to have ceased to exist only when the appointment is given. and then he will be guided by the service rules. Now B says an appointment offered made on compassionate ground cannot be transferred. So he is never granted. You have kept his claim pending.
No, mother or the wife
Correct,
withdraw her application.
correct. She did not withdraw her application. Show that she has withdrawn her application.
That is the language.
Read the language. She says, I have withdrawn.
Can you see the order password?
No, where is the application? You are saying she has withdrawn. Your order will not determine. What she has said, your order will not determine. Let us see what she has said.
Can you see the input order?
Please show us that she has withdrawn. We are not going to look into your order for this query. You are repeatedly saying that she has withdrawn in 2017. Now, where is that application where she has withdrawn? Show us. You may write anything, that will not become a gospel.
I'm for the petitioner.
My lord,
In this
on the
matter,
occasion,
I'm submitting first thing.
just a minute, I have some objection. My lord, I was placing this matter with regard to the stepping up of pay. My lord, remember lordship is, and I, lordship, directed, lordship is one of the order passed.
The circular, lordship.
Where two circulars of the railway board will be appearing, my lord. This will help my case. My lord, I have tried to ascertain the circulars. But
And this is the circular. Kindly see the circular.
20th July and 29 July.
Yes, yes. This is the circular. And
your lordship.
I
He has got it.
am reading the circular. I am
Just
reading the
exchange,
circular.
just exchange a copy. Give him the copy.
So that I can take instruction. I come back after.
No, what instruction? You proceed on the basis of the circular. What instruction?
I have not seen this, sir.
You are the railway, you
I'm-
can't come up.
I'm the
And-
petitioner.
Okay.
My lord, I have shown
Yeah.
your lordship to
Give him a copy. Give him a copy.
No, no, he have not annexed in that way.
Sir,
No,
give him a
this
copy.
circular challenge. He has not
Senate
annexed
counsel
it.
for the petitioner. Call the next case.
Instruction, I will come back on next Monday.
There is no instruction.
No.
দাঁড়াও জুনিয়রে করে লাগছে
Next.
22 নামটা দিয়ে দিয়েছো
I'm for the petitioner.
এই নামটা দিয়ে দিয়েছে আমাদের
Lord, that the issue is this, my lord. My lord, before the tribunal, my lord, they have handed up, my lord, documents. Wherein on that basis of the said documents, my candidature has been, my lord, cancelled, my lord. On the last occasion, your lordship, my lord, directed my learned friend, whether the said order has been, my lord, supplied to me or not, my lord.
21/8/24.
Yes.
It was served.
Prior to this served, my lord, I have given that, my lord, I am led by, my lord, I am led by,
If you are led by, then allow him to submit. You please don't send.
my lord.
There is a specific query. If you are led by him, we hope you have shown him
No,
the
no,
query.
my lord, what?
Have you shown him the court's query? We are only wanting the answer to that query, nothing more.
Tribunal order over by sir.
My PhD, sir.
When? কি লাগিয়েছে আমার বাড়ির উপরে? কি লাগিয়েছে দেখো তো।
Then the next document is a testing. This is regularly called Rotkaya Jari Korinam.
ওয়েটা কবে করেছিলাম ওয়েটা পেনটা তো পেনটা পেনটা Tribunal on 22nd of August 2024, my lord. My lord, the tribunal, when the matter was admitted for hearing on 15/3/2023, which is at page 55, my lord, direction was given to file reply and rejoinder, my lord. Thereafter, several dates, my lord, elapsed. State did not file any, my lord, reply to the original applications. Only at the time of final hearing on 22nd of August 2028, they handed up our documents, and on the basis of said documents, the tribunal has rejected my applications, my lord. If your lordship kindly takes pen to the impugned order.
No WS was filed.
No. Only at the time of hearing, they handed up one documents. Even at the time of hearing, we prayed for these documents. It was not supplied to us also.
So you can move the tribunal if you want. Assail this order.
Bring back this matter to the tribunal.
You can approach the tribunal, we'll grant you liberty.
Just, my lord, unless, my lord, these documents under which, my lord, which provisions they have rejected my claim, I have a right to know, my lord. My lord, kindly consider.
We have not understood that. Therefore, we are asking you, whatever it is an order of rejection. It has to be challenged by you. You challenge it before the tribunal. Who is stopping?
As of date, we don't have that objection, my lord.
Give you. We'll direct them to give a copy right now. They are giving you right now. We challenge.
And my lord, these, my lord, kindly bear me for a minute, my lord.
Yes.
My lord, this OA application was filed, my lord, way back in there 2000. My lord, just for my satisfaction. My lord.
You filed. They did not file WS on the last day. They give a.
No, but I'm not on that.
That you have already.
Another point, my lord.
Yes.
My lord, 2023, the OA application was filed challenging that since I have been acquitted from all the criminal charges, kindly give me this appointment. My lord,
We are not going to enter the merits of the matter. There is no decision of the tribunal.
Yes, my lord.
There is a rejection.
No decision.
That rejection has to be challenged. The only place you can challenge it, the tribunal has not decided
No.
whether this decision is correct or not. The tribunal has already only said that it has become infructuous. So you challenge that decision. The tribunal will decide.
My lord,
whether when an employment notice is issued and you participate in a proceeding, the appointment will have to await the time you become eligible or not. Whenever you become eligible, at whatever age it is that you become eligible, that is an issue which they have to consider. They will consider.
And in the middle 2017.
Whatever it is, we don't know. There is no decision on merits.
No.
We are also not going to enter the merits. They have passed an order. You have the liberty to assail it. Instead of saying infructuous, we'll say we reserve your liberty to assail the order.
Challenging the purpose. Then we have to file a fresh OA, my lord.
You have to.
Copy of the rejection order, my lord.
He's giving you right now. He's giving you right now. The
HON'BLE. Okay. Hold.
Is that the one?
My lord. Mail, seeking your office of. No, this is not rejection order. Kindly see.
21/8/24.
Yes, 21/8. This is not a rejection order.
What is it?
My lord, this is my lord communication from the DIG police headquarters to the my lord police West Bengal superintendent of police with reference to the it is intimated that Buddhadev Bhattacharya Mandal has already crossed the he has been
Yes,
acquitted.
that is the.
My lord, there is no rejection order, my lord.
He has already crossed the age of 45 years.
But my lord, they have not stated that your candidature has been rejected. My lord, kindly see, my lord.
Read it.
My lord. My lord, with reference to the above, it is intimated that Sri Buddhadev Mandal has already crossed the age of 45 years. He has been acquitted from the judicial magistrate first court such and such, but no order of his joining is given by this learned court. What the learned court? Necessary action will be taken on receipt of the order and instruction from the Honorable West Bengal Tribunal.
What is it, Mr. Mukherjee? How can you proceed like this?
In 24, which is now handed over just now, my lord, in that also reasons for cancellation in terms of West Bengal 80 order, administrative tribunal order. They have not rejected, my lord, as of date. Type of documents bolche, sir.
So there is no rejection order.
No.
চুপ কর না 21st August, yeah, the decision was taken because he has been acquitted in a criminal case. That's it. Handed over. 21st August 2024 decision is
এটা নয় এটা নয় স্যার এইটাই এইটাই এটা তো এটা নয়
of eligibility already crossed the age of 45 years. He has been acquitted by the judicial magistrate passport, Behrampur, Murshidabad from the criminal part. No order is joined by the landed court. Necessary action taken or received the order from the
In terms of this order,
in terms of this order was passed.
that is 67.
So, see the decision on 21st August 2024.
Where is the rejection of 21/8/24? Your specific stand is that there is a rejection on 21/8/24.
No, rejection order is of 6th November 20.
Correct. So there is no rejection of 21/8.
There is only communication of the order.
There is no rejection of 21/8. Now take down. Come.
Below 21st August
If you
2024.
would have listened to our order, you would not have said this. If you would have listened to the order we have just dictated, would not have made such submission. We have just said that there is no order of 21/8/24. And it has been rejected on 6/11 and we are giving you liberty. Still you are making this prayer. You are more interested in just saying something. You should hear us also when we say something. Yes. You say late. He has given you a copy.
Before the tribunal, the state should have
Next order. Next case.
23.
for the petition.
My lord, heard this matter on the last occasion, my lord. This is regarding recruitment to the post of Krishi Poyukti Shayok, where the coordinate bench has already decided, my lord directed the learned counsel appealing for the PSC to take instruction whether that judgment has been passed in the same recruitment process or it's relating to other different recruitment process.
Yes. What is your answer?
Last occasion, Lordship has asked that whether that is the same recruitment process or not. But
Pritam Gosal is arising out of the same recruitment process. The same order has to.
but for the purpose of judicial review, Lordship can hold the the law because in the Kamshikonar matter, the self-same law was involved, and in that matter, the court holds otherwise, Lordship, and that in this specific case also, prior to the commencement of the interview, we have informed all the candidates that we are going to impose cut-off marks upon all the stages of the recruitment process, Lordship. And it was informed prior to at least 20 days prior to the commencement of the interview. As the selection process was conducted by Staff Selection Commission, not the Public Service Commission. After commencement of the selection and after taking the written examination, Staff Selection Commission was repealed, Lordship. And then the Public Service Commission conducted the rest of the examination. And in the judgment, it is
Lord Counsel, you have just stated that it was the qualifying marks was intimated prior.
Lordship, that is not a qualifying marks, that is a cut-off marks. The petitioner,
show us-
the petitioner was not.
Show us when it was.
Unless the exchange of affidavit, I cannot disclose the record because I have the soft copy. Then Lordship.
But when we get to the
Yes, Lordship.
would have coordinate bench has already found that problem.
For the tasting for the, under the judicial review, Lordship can hold the contradictory view would be only for the test of the. Tribunal, but before the tribunal, it was not finally adjudicated, Lordship.
Page 64. Begins at 60. The relevant portion is paragraph 18 at 64. But not I place reliance on page 64 of the writ petition being the coordinate bench judgment. Paragraph 18.
For the tribunal, where is your WS?
Not filed in this case. But in fact, the tribunal directed exchange of pleadings. The state did not use any pleading. Then when it came to final adjudication, the tribunal said it requires a substantial question of law adjudication. Therefore, I shall not decide.
So there was no opportunity to file a WS there.
There was an opportunity. That's at page That's an order of 29th February 2024 at page 79.
Let them file affidavit. Affidavit in opposition. We filed with the
Item number 24, my lord, I'm for the petitioner, my senior, my lord. Item number is online.
Well, this matter was heard out by your lordship. Only one thing stuck to my lord, that where the past service would be considered, and there is a judgment of Justice Shah, my lord, we could lay hand, where the Honorable Supreme Court says, yes, for the purpose of continuation of service, past service should be taken into consideration. That's the only point which, on the last occasion, lordship really wanted us to get this.
Can you point out the relevant part of the judgment?
Yes, yes, my junior will point out.
Yes.
Mark করেছিলাম কোথায় আমার?
Kindly come to paragraph 44 once.
আমার মার্ক yes.
Then 48.
ওইটা ওখান থেকে দেখাচ্ছে আমি
You said paragraph 44.
44, 48. 48 is it is submitted that in the case another references All India Judges Association versus Union of India.
No, there is a variance. There is a variance.
Yes, and 54 is the findings.
No, paragraph 44 starts with on the issue whether commission.
Yes.
It's not
on the issue whether commission vendor and bearers after the absorption on the permanent sanction post in the railway is entitled to for pension or not. Different references are considered in this judgment. And paragraph 54 is the observation.
54. Yes.
And for Union of India, my senior is engaged in another court, Supreme Court, not.
But my lord wanted to know whether the past service would be considered or not. That's all. The direction be passed, let them consider afresh in terms of the CAT's order. CAT's earlier order, date of Dibbendu.
What a date it, my lord?
9th of August probably.
The senior is not there. Let him be here. 5th December 29. Take it up tomorrow.
Okay.
Give him a copy of this. Give her the site. Just share the citation. It is a reported judgment.
Yes, it's a recently reported. Okay. Deeply obliged.
Let's see one more. $25.
I'm not keeping well. I'm running temperature since the matter is sensitive.
You are not well.
I am for the petitioner.
Let us see whether what he has to say.
My lord, the subject matter of challenge in this application is an order passed by a division bench of the Central Administrative Tribunal, allowing the respondent's application and directing us to drop the disciplinary proceeding initiated against the respondent herein, and on account of delay and laches for non-compliance of the order of the appellate authority dated 19 September 2006. By the said order, the department was further directed to release entire retirement benefits within 3 months of the date of the order. Now, my lord, the facts are stated in details in the judgments, which I shall place immediately hereinafter. But, my lord, to cut the matter short, I submit that the application before the tribunal should have been dismissed by the learned tribunal in view of Section 20 of the Administrative Tribunals Act 1985. My lord, Section 20 bars exercise of jurisdiction of the learned tribunal in entertaining of an application filed under Section 19 of the said Act. It speaks that the tribunal shall not ordinarily admit an application unless it is satisfied that the applicant has availed of all the remedies available to him under the relevant service rules as to redressal of the grievances. Therefore, my lord, the tribunal was required to record the reason for following the extraordinary path in entertaining the application in the initial stage, as also to point out as to why the extraordinary power was exercised in entertaining the application for consideration at the threshold where, on the face of it, it appeared that there was an alternative remedy, A. B. The applicant therein was bound to adhere by the same. And my lord, most importantly, records will reveal that the petitioner himself surrendered to the same jurisdiction where he asked for extension of time for a fortnight. Thereafter, surprisingly, surpassing everything, moved the learned tribunal, although the time for extension was prayed by him and was granted by us. The order does not reflect any consideration in this regard. My lord, I pause for a moment here.
Where is your WS?
Yes, my lord.
Where is the WS filed by you?
My lord, I may assist the court here. In page number, annexure P4, page number 22, the appellate authority says that I send you everything. Kindly answer me.
Where is the reply or WS filed by you before the tribunal, we are asking?
Page 190 of the supplementary affidavit, my lord.
Allow us to see.
My lord.
Yes.
My lord, may I assess the court by taking you to paragraph at page 193 of this supplementary affidavit. The first paragraph.
What is the alternative remedy he should have exhausted?
Yes, my lord.
What is the alternative remedy he should have exhausted?
The alternative remedy was that the appellate authority, where he the alternative remedy was you were supposed to go to the appellate authority.
Was the order to be assailed before the appellate authority?
My lord,
Which order was to be assailed before the appellate authority?
he was supposed to answer to the appellate authority.
Where is the question of appellate authority? You have given him a note of disagreement.
My lord, he had submitted, he had got the job.
Is not the point. That
My
we
lord.
have seen. Dispute of 717 marks and 400 something marks.
My lord.
That we have seen. Much water has flown thereafter. There are 3-4 proceedings before the tribunal also.
My lord.
Finally, in 2006, the tribunal said, you give him a note of disagreement indicating the points of disagreement so that he can respond to you. After that, you take 13 years to issue the note of disagreement to him.
My lord.
Now, after issuing the note of disagreement, he comes to the tribunal. Where is he to go? Where should he go? That we are asking. If you file
Department of Post. It is the Superintendent of Post Office, South Presidency Division, Baruipur. Where a disciplinary proceeding was initiated against him.
you a simple question. You,
My lord.
you said that without exhausting the alternative remedy, he has come.
My lord.
You take 13 years to issue a note of disagreement.
My lord, Annexure P4, page 22.
Take 13 years to issue a note of disagreement.
My lord.
Now, against that note of disagreement, what is the alternative remedy? That we are asking.
My lord, there were some latches, a latch of 14 years.
Said he was to exercise your point that you have urged is that he did not avail alternative remedy in terms of section 20. You have made a specific objection that he could not have. Where will he go if you stay with the order of the tribunal for 13-14 years? One fine day you awake from your slumber, you issue a note of disagreement. What should he do?
My lord, may I assist you? Please permit me.
Complete your first point that you have submitted. We are asking you to complete that first point.
Yes, my lord.
Where is he supposed to go?
He's supposed to go to the appellate authority for that.
Appellate authority.
Yes, my lord.
Against a note
Because
of
he himself said that.
Under which provision?
On the provision of the Administrative Tribunal Act 1985, Section 20.
Appeal will be filed under the Administrative
No,
Tribunal
no,
Act.
no. I beg your pardon.
Come to the CCS. Come to the appeal
Yes, ma'am.
provision.
Yes, yes, ma'am. Service rules.
Yes. What is the provision of appeal?
Appeals. 23, Rule 23.
Yes, read Rule 23.
Order against which appeal lies.
Yes.
Subject to the provisions of Rule 22, A government servant may prefer an appeal against all or any of the following orders, namely: 1. An order of suspension made or deemed to have been made under Rule 10. 2. An order imposing any of the penalties specified in Rule 11, whether made by the disciplinary authority or made or by any appellate revising authority. 3. An order enhancing any penalty imposed under Rule 11.
Neither of these orders, therefore no appeal can be filed. Neither it is imposing a penalty, neither it is an enhancing a penalty, neither it is any of the orders which are specified thereafter. Therefore, we ask you, where is his remedy of appeal?
My lord, E2.
Yes.
For the period from the date, oh, no, my lord.
There is no determination.
No,
of
no, my
time
lord.
allowed.
I'm sorry.
Yes, any other point?
My lord, I'm trying my level best. 24. Appellate authority. A government servant, including a person who has ceased to be in government service, may prefer an appeal against all. Oh my God, not this.
Should have read these provisions before coming to the court. This is not the place. No, no, no. You proceed any other point. What is this? You're raising an issue without even going through the relevant.
Achha, my lord, may I get into the facts of the facts of the
Not going to go into the facts. Any other ground on which you assail the order? We are not going to go into
Okay,
facts.
yes, my lord. Yes, my lord.
It's not an appellate forum that will go into the facts.
No. To Annexer P4. It reads as, whereas a disciplinary proceeding under Rule 14 of CCA Rules 1965 was initiated against Sri Torun Kumar Pramani, PA South Presidency Division Vaidi, this office memo B/T 38 dated 8/10/1990, currently working as PA Rudranagar SO. Page 22, Annexure P4. My lord, I'll come one by one. Please give me a
to issue a note of disagreement for the grounds on which you have disagreed with the findings of the inquiry officer. You have taken 14 years to issue the note of disagreement. Tribunal has held it to be a belated action, and the tribunal has interfered with the proceeding only on the point that it is belated. Now tell us how it is not belated. That is the only issue.
My lord, but the tribunal is weighing the laches more than the fault on the part of the respondent hearing. He has got the job submitting a mark sheet wherein he has got a 717 marks.
Yes.
And चुप करो. And my lord, Annexure P2 18A is the West Bengal Board of Secondary Education annexure, wherein it shows that he has got 424 marks. And 18 is of the headmaster of the school, who has also given a certificate which shows that he has passed in third division, got 424 marks. So the tribunal is weighing over the laches more than the crime.
Yes, we have taken note of that. Anything else?
My lord, the tribunal should have dismissed it there. That is my humble submission. And my lord, the previous day, my lord had directed them to put that duplicate copy, because of which this inquiry was. Sorry, my lord, I beg your pardon. दाओ. तो judgment to the दाओ. My lord, as far as the latches are concerned, may I please a recent judgment of the Supreme Court of India
Please give us.
of Justice Abhay S. Okha and Justice
Just give
Ujjwal
us.
Bhai.
Name is not relevant. It is judgment of the Supreme Court. Give us.
Reportable judgment, my lord.
You have given a copy.
I will. Page number 35, paragraph number 31. Page number 35, paragraph number 31. As has been held by this court on more than one occasion, a subsisting disciplinary proceeding, that is, one initiated before superannuation of the delinquent officer, may be continued post-superannuation by creating a legal fiction of continuance of service of the delinquent officer for the purpose of conclusion of the disciplinary proceeding. I stop here. That is my humble submission.
My lord, the charge was issued in the year 1990.
5-10-1990.
Yes. Lordship has claimed. First order of the learned tribunal is at page 164 of the supplementary litigation.
No, what is the date of the inquiry report favorable to the petitioner?
Inquiry report was already given. That is, the inquiry report is dated.
Yeah.
94.
You have the date.
'99.
Now, how many OAs?
First wave 157.
How many OAs?
Five.
5 OAs. Prior to this, or this is the 5th? You sit down. You are unwell. Why are you standing? Can you just, in a seriatim, give us the OA numbers?
152 is the OA.
OA number 152 of
442 of 1993.
152.
Page 1
No, just give us the 5 OA numbers in serial.
of 1993.
442 of 93. That is the first one. In this, what?
Yes, madam.
Second?
Second one is 335 of 1994.
Yes.
Then one next way is 102 of 1995.
Yes.
Next way is of 625 of 2000.
And then the present one.
Yes, present one.
Now, in 442 of 93,
Yes.
what was the subject matter of a sale? At which stage that was filed? Removal order was a sale. The order of removal dated?
In the year 1995.
No.
Page 152, madam.
In 442 of 93.
Yes, removal from service.
Rem-
First removal from-
Correct. That is what we are seeing.
Yes.
Removal dated 20th April 93.
20th April 1993.
Yes. And that was set aside.
Yes.
For issuing show cause afresh.
Yes.
You did not give us 1082 of 2000.
That they have not given.
So this is probably the 6th then. This is not the 5th.
169, sorry. 160.
1082 is also one of the OAs filed. That is the last one. Prior to this.
The last one is 6. That is
9890. Yes, 983 of 19. But before that, the last one is perhaps 1082 of 2000. And before that, 625 of 2000.
Yes.
10295, 33594, and 44293. 6 or any more? No, we just want to be sure of the
Yes,
facts,
my lord.
therefore we are.
No, I've checked, my learned senior has checked up.
Two objects. Oh,
One order I'm just.
My lord, I have nothing much to say. It proves for itself.
oh, sorry. Can you just please give us a list, chronological list of the ways? No, tomorrow. Very briefly, don't be very elaborate, just the basic.
Only one thing, my lord, my learned friend is relying upon a decision that is relating to initiation of proceeding prior to.
We have seen that. Whether it can be continued post-retirement, the service rules somewhere, they have a provision that by an order it can be extended for the purpose of inquiry. Some places they say it cannot be done. Some places there is a time frame. That is not the issue here.
Yes.
The issue here is whether the proceedings can be continued after such a delay or not. That is only.
My lord, the most important. My lord,
Huh?
the
It was issued.
Correct.
And 2019 they give the so-called.
5/10/1990.
Yes. After
5/10/1990, 1990, somehow it has been No, see that going back may not be of much significance because up until 2000, the tribunal has granted them the liberty to
4 months.
no, whatever it is, but up till 2000, so you cannot say that you cannot count it from 1990. You have to start from
That's why
2000.
tribunal said after 13 years, even after the appellate order.
Correct. So therefore, the tribunal has at least allowed them an opportunity till 2000 to file to submit 2006
Yes, that's why 13 years, my lord.
to give you the notes of disagreement. So therefore, prior to 2000,
Not material.
you cannot count that as a delay. Now from 2006 to 19,
13 years.
that is the issue, whether they can be permitted to do this or they cannot be permitted. That's the only thing. Yes, you were not here.
Excuse, because code number 11, one matter was going on. In the midst of that, I could not come.
No, you are here, therefore we are asking you.
Yes, now I am here. My lord, on the previous day, what I submitted subject to your lordship's correction, my lord, there is a difference between a delay at the stage of initiation of a proceeding and a delay at the midst of a proceeding. It is an admitted position here that the proceeding initiated in time up to the stage of inquiry, submission of inquiry report, that was already done and then that attend finally. At this stage, there is no dispute regarding that. The departmental appellate authority directed to start only from the stage of issuance of the note of disagreement and calling for the second show cause. Therefore, my lord, if at this stage it is barred, the result will be a pendency of a judicial proceeding because a proceeding was initiated, quasi-judicial proceeding, I stand corrected. A proceeding was initiated, it continued up to the stage of inquiry and submission of inquiry report, and there it will stop. In that case, in this connection, my lord, what I submitted on the earlier occasion. Kindly permit me, because examples are not permitted in the court. In this court also, some old matters come in the list for final hearing after a lapse of 10 or 12 or 14 years. We not delay in the midst of a proceeding, if it is a cogent ground to frustrate the proceeding, then these old cases cannot be also heard on merit. But in all the honorable high courts and including the honorable Supreme Court, all old cases are treated on merit, taking into consideration the merit, irrespective of the fact that there is a long gap in between. So if that principle is applied, then the tribunal, with due regard, acted illegally. It gave excessive adherence to the question of delay without taking into consideration that it is not at the stage of initiation of the proceeding. Yes, that is. And secondly, my lord, next point is, my lord, the point against the respondent here, the delinquent employees, at the time of getting appointment, he not on the merit. My lord, on this point, on the merit, my lord, I have one point to submit before your lordship. If the delay comes in picture, it is the settled principle now, pursuant to some series of judgments of the Supreme Court, that the case is to be decided and taken by taking into consideration the facts and circumstances of the case also, whether the question of delay shall survive or whether it shall frustrate the merit of the matter. Therefore, only adherence to the question of delay without taking into consideration the facts and circumstances of the case, that is a part of mistake on the learned, part of the learned tribunal. The allegation here is that an incorrect, I am not saying that on the previous day your lordship did not allow me to use the term fake. I am not using it. An incorrect mark sheet was used by a petitioner. He produced it on the basis of that he joined the government service. Throughout the career, till the age of superannuation, he went on accepting salary from the government exchequer. And now he is demanding the retirement benefit till the end. On the basis of a wrong document, whether this can allow to stand simply because of the ground that there is a delay in the midst of the proceeding, not at the very inception. It is not the case that a de novo proceeding was directed to be initiated. To what extent the question of delay is to be taken into given weightage, and whether the matter which is already initiated, which is now pending, whether it is to remain pending forever or it is to be disposed upon merit. These are the points at this stage for consideration. These are the points here to be considered. My submission is that the learned tribunal gave excessive adherence on the point of delay. I am telling your lordship the truth. It was submitted by my learned junior. I did not get any opportunity to go through it. Paragraph? Paragraph?
Page 35, paragraph 31.
He did not show it to me earlier because, and that is why. a subsisting disciplinary proceeding, one initiated before superannuation of the delinquent officer, may be continued my lord. A delay which is not at the initial stage, it is at the mid stage.
Correct. So whether the delay can defeat the employer's right to proceed.
Right to complete the
Complete the proceeding. That is, this will not apply.
No,
will have
regarding initiation, the question is not there.
Give this back. Give it back. That we have understood what you are saying. There is no delay in initiation.
Yes.
It is continuing. We have been pursuing the matter. Therefore, having a regard to the enormity of the allegation against him, he has obtained appointment by misrepresenting his marks.
My lord.
And therefore, whether delay will defeat my right to pursue the matter against him or not. That is
Practically, what the delinquent employee did is an offense. Whether that will survive on the question of delay. And the second point is that if the proceeding is blocked at this stage on the ground of delay, the result
And
is
where
not
are
the
your-
position that there will be no lease, there will be a pendency.
Where are your points of disagreement? Show us the note of disagreement. 2019 note of disagreement.
পেজটা বলো তো। পেজ কত? My lord, in the supplementary affidavit, page, it is page 23 of the petition.
Supplementary or petition?
No, page 23 of the petition.
And where is the inquiry report? 181191.
My lord.
The inquiry report of 181191. Where is it? Inquiry report. 181191 inquiry report.
Inquiry report টা কোথায়? 181191.
That is the only inquiry report. There is only one inquiry.
Inquiry report টা এখানে অ্যানেক্স করেছো? Page 58.
If you kindly come to page.
My lord, page 58 of the supplementary. Supplementary. Page 58. হ্যাঁ, ওই। 140. 140.
Yes, page 58.
I'm sorry.
Yes, take down. In view of the paucity of time today.
अरे यार